that would be helpful. It just helps with any kind of distraction. Thank you very much for that. My name is Gordon Reid. I'm a reporter with the Scottish Government's Planning and Environment Appeals Division. This is the pre-examination meeting in relation to the inquiry into the Section 36 application made under the 1989 Electricity Act by Loch Kemp Storage Limited for a pump storage electricity generating station at land at Dell Lodge at Whitebridge. I have been appointed to consider this Section 36 application and to submit a report to Scottish ministers. Ministers will then decide whether or not to approve the application after consideration of my report of the inquiry. This meeting is being recorded and broadcast live. My staff will be watching and are available in case there are any technical difficulties. This meeting will be made available on the DPA webcasting site so that those not participating today can also view it. I would just remind people that by taking part in the meeting, you're consenting to being filmed and to the use and storage of those images and sound recordings and any information contained in them for webcasting and training purposes and for the purpose of keeping historical records and making those records available to the public. As I said, I would ask you to keep yourself on mute during the proceedings this morning, unless you need to speak at any point. There are quite a few people at the meeting this morning, so if we can all be patient with each other and with myself as I bring people in at appropriate times. If I do miss a hand being raised, then please feel free to draw my attention to that. I would request that if you're not the lead spokesperson or are just viewing the proceedings, if you could turn your camera off, that will just help me manage the number of people that I am looking at on screen at any one time, and then I can make sure that my attention is being brought to the appropriate person. If at any time you want me to slow down or you're communicating with your team and you wish that we pause, then please just make me aware of that so that we can do that. Also, if you have to leave in the case of emergency, please do that. Don't hesitate. So the purpose of today's meeting is to discuss the procedural arrangements for the inquiry necessary to consider this case. I would emphasise that there will be no discussion on the merits or otherwise of the application or of parties' cases. So we're really looking at setting out the procedures today rather than any elements of your individual cases. An agenda was circulated for this meeting in the first week of November, and hopefully that will give you time to consider my current thinking on further procedure before coming here today. As we said, that was my initial thoughts, so that will be discussed as we go through the meeting. The applicant did draw my attention to a couple of matters on the agenda that required clarification. I had missed an R out in the spelling of a potential viewpoint, which I have now inserted, and we will pick that up as we move through it. And the second point was I was too busy looking at Invermorriston rather than River Morriston, so I should have referred to River Morriston SEC rather than the actual place at Invermorriston. But again, we can pick that up as we progress through. I will be keeping a record of our discussions and I will circulate a note of the meeting which will include any key decisions as soon as possible, and I would intend to do that within 7 days from today. And that will take the form of a formal procedure notice as well. And the notice will set out all of the procedural arrangements that we have agreed over the course of today. As I'm taking notes, I may have to slow you down when you're speaking or ask you to repeat something just to make sure I have captured what you've said accurately for my note. Finally, as we go through the process, I hope I pronounce any names appropriately. If not, then please advise me if I have mispronounced anything, and that's not an issue. So before we go on to item 2 on the agenda, are there any initial questions that any party has that they need to raise? I'm seeing shakes of head. Okay, now if you could just bear with me a second, I have a slight issue with my screen that I'm not seeing everybody all on the one screen. So if you could I just want to make sure I've got everybody, because I was looking for somebody and they're on a second screen, which isn't helpful because I don't want to flick back and forward. So if we can just pause for just a couple of minutes, I will ask my technical team just to sort me out. So bear with me for 2 minutes, please. I apologise for that slight delay, but I've now got everybody who's got their camera on screen, so I can see you all in the one place, which is very helpful for myself. So going back to that, are there any matters that anybody wishes to raise before we move on to the next item? Seeing nods of head, that's fine. So item 2 is an introduction of those representing the parties at the meeting. If I can ask the lead spokesperson for each party to introduce themselves, and anyone else who will be participating today. If you are just viewing today, I've got your name on there, so you don't need to introduce yourself. But if you are participating, then that would be helpful. So if we can start firstly with the applicant.
Good morning, sir. My name is James Finley, King's Counsel. I'm instructed by Patrick Monroe, Burgess Simon.
Thank you. And for the council?
Morning, sir. I'm Alistair Burnett, King's Counsel, instructed by Arlene Gibbs of the Legal Department of the Council, who's also in attendance but not planning to speak unless something unusual comes up.
Okay, thank you. And finally, let's go through the other parties. Let's start with the, no particular order or priority here, it's just on my list. The Ness District Salmon Fisheries Board.
Morning, sir. Ian Kelly from Ian Kelly Planning Consultancy Limited, representing the Fishery Board. The Chief Executive is listening to the call, but will not be participating. It will just be myself. Thank you.
Okay, thank you. And for Strathnairn, if I've pronounced that correctly, Community Council.
Hello.
Yes, I can hear you.
My name is Julie McCrae, and we are speaking on behalf of Strathnairn Community Council. It would be myself, Ro Atkinson, and Maria Cober.
Okay, thank you for that. And Stratherick and Foyers Community Council.
My name is Mark Hindley, Chair of Strathnairn Foyers Community Council.
Okay, thank you very much, Mr. Hindley. Okay, and for Bullskin Biodiversity Group.
Hello, my name's Neil McKenzie. I'm representing Bullskin Biodiversity Group, a local environmental association living near the development. However, I will be cooperating with the British Lichen Society and BugLife, who will probably be taking the lead on this.
Okay, so who would be my lead person to refer to? Would I just refer to BugLife? Mr. Sanderson, did your hand go up there?
Yes, it's Neil Sanderson who will be taking the lead on this.
Yes,
Okay.
yeah, I'll be taking the lead on that group. Yeah.
Okay, that's very helpful. Thank you very much for that.
Thank
And
you.
you've introduced yourself as well at the same time, so I won't sort of come back to you.
Okay.
And I'm just going through my list here. If you are speaking, then that's fine. I've got Peter McMillan.
Hello, Peter.
Good morning.
Good morning.
Are you just observing this morning, Mr. McMillan?
So I'm viewing. I'm not quite sure. I'm a local businessman and resident with a sort of Scotland-wide business, and I kind of I like to watch and take part if I'm asked to.
Okay, that's fine. You can watch. If there's any questions or queries that's going through, please come on and raise your hand. That's fine. There's no problem with that. Port of Inverness.
Good morning, Sinclair Brown. I'm the Chief Executive of the Port of Inverness. I'm here to observe, but will raise my hand if there's any queries. Thank you very much.
Okay, thank you. Now I've got Save Loch Ness. Now, Mr. Kelly, you were down for that as well, I believe.
Yes, sir. I do represent them. Their primary interest is in the Glen Eric pumped storage scheme on the other side of the loch. They see many of the issues for this case as being similar. Their position is that they will decide their level of participation in this inquiry once they see the minute of today's meeting. So their final position has not yet been decided, but if they participate, I will represent them, sir.
Okay, thank you for that. Now, the remaining parties I have are from interested parties representing themselves. And I'll just go through these. Sarah Byrne. Your microphone's still on mute.
Good morning, my name's Sarah Byrne. I'm here as a local community resident.
Okay, thank you. Maria Coburn.
Good morning, sir. I'm a local resident to Strathnairn and I also sit on the Community Council.
Okay, thank you. And now, have I missed anybody else? Is there anybody else that's here that I have missed out? If you just come on screen, that would be fine. Raise your hand if you've come on. If I've missed anybody that's participating, just speak. That's okay. Mr. MacLeod.
Yeah, good morning. I'm George MacLeod. I'm the MD of Highland Shipping Company. We have a partnership agreement with Scottish Canals to utilise the canal system for moving freight to and from all these pump storage schemes. Thank you.
Okay, thank you. Anyone else before we move on?
Yes. Good morning, sir. I'm Craig McAdam, Director of Conservation at BugLife. We're going to be working with Boskin Biodiversity Group and British Lichen Society on the terrestrial ecology aspects and supporting Ness District Salmon Fishery Board on the aquatic ecology.
Okay, thank you for that. Okay, I think Julie Harvey, I can see a hand up. Apologies, there's that many here. I'm just trying to make sure I work my way through, so you bear with me. Yes.
Thank you. Good morning, sir. I'm here as a local community resident and having made representation to the ECU. Thank you.
Okay, that's great. I think that's everybody who's on the call this morning. Yeah, I'm not seeing anything else. Okay. Are there any apologies before we move on? Okay. So moving on to item 3, The code of practice for handling inquiries. There are no detailed procedural rules for the conduct of inquiries under the Electricity Act. However, the DPA has produced a code of practice which has been modelled on the 2013 Planning Appeals Regulations, and I intend to apply the code of practice in this case. If you haven't seen it, the document is available on the DPA website, and I will include it in a link in the note of this meeting so people can access that. Essentially, the code allows for flexible procedures. Each issue that requires a further procedure will be dealt with by the most appropriate method of examination. This could be an inquiry session, a hearing session, or further written submissions. On some issues, sufficient information will already have been submitted, and I will not require further procedures. However, when I write my report to Scottish ministers, I will take into account all of the environmental information submitted by the applicant, together with all the consultation responses and any letters of representation already lodged. Also, the type of procedure being followed, or indeed the absence of any further procedure, is not an indication of the importance of a particular issue. It just reflects that I feel that I have sufficient information in order to write my report. I'm aware that for some people that this process may well be unfamiliar, and so if I can explain briefly what further procedures in the inquiry process may take. So the first that I've referred to is a hearing session. These take the form of a structured discussion between the parties involved, which I would lead. There will be no formal leading of evidence or cross-examination. I would prepare an agenda for each of the hearing sessions in advance. Everyone who has advised me that they want to take part can participate in a particular hearing session. There is no need for legal representation, although parties' lawyers can take part in the discussion. Hearings are generally more informal than inquiry sessions. In advance of a hearing session, all the participants would be expected to prepare a hearing statement with regard to the scope of their evidence for the particular matter being considered. So that's one option for further procedure. Secondly, the inquiry sessions. Each party would be invited to present evidence in turn, and this would be subject to cross-examination by those of an opposing view. Usually, parties are legally represented, and lawyers will do the cross-examination or questioning of the witnesses, although it is not essential to have a lawyer at that. I may also have questions as part of the inquiry process. Inquiry sessions are more formal than the hearing sessions and are particularly suited to topics where there's a lot of technical evidence. Again, written materials required in advance which states your case. Normally, an inquiry report and a precognition would be required. Each party at the inquiry session would present evidence in chief. That would be subject to cross-examination with an opportunity for re-examination. The third further procedure would be further written submissions, which I have indicated and outlined on the agenda already. These would seek written responses to questions set out by myself, and these take the form of a formal procedure notice, and in this case would normally be part of the note of this meeting. There would then be the opportunity for relevant parties to respond on the matters raised in the further information provided. You will see in the appendix of the agenda, on the basis of the submission of parties to date, I've already set out my initial thoughts of how the case could proceed, but we will discuss that today, so that's not fixed. Also, site visits would be part of evidence gathering, and I would intend to carry out site inspections, but again, we'll come on to that matter later. So that's really just setting the general context for everybody to be aware of the options of further procedure that we have available to us. So moving on to item 4, this is just an opportunity for the applicant, if there are any updates that they wish to make myself and other parties aware of.
Thank you, sir. No, there are no updates, relevant updates.
Okay. Thank you for that. Item 5, this is just in place in case there is additional information in relation to the EIA regulations. This is can be required through the inquiry process. And I'm just again to the applicant whether there's any additional information likely to be submitted. I did review the position statements, which didn't make any indication that there would be, but if the applicant just clarify the current position on that.
Thank you, sir. No, you're correct there. No, there's no intention to submit further additional information at this stage.
Okay, thank you. Okay, so moving on to item 6, which is the provisional assessment of the main issues to be addressed and those requiring further procedure. If you've got the agenda, you'll see at Appendix 1 that there's a table there which just set out my sort of initial thinking on matters. So, as I've indicated, all of the written material submitted by parties will be taken into account, including the submitted representations and objections. So if you've already submitted your full detailed case in your written representation, that is before me and that will be fully taken into consideration. I would also emphasise that all parties who wish to be involved in an inquiry session at this stage should understand that they need to prepare and submit their case in advance to allow the other parties to see what evidence is being presented and to avoid any surprises on the day. So parties may wish to rest on their existing representations, and that's fine, or they may wish to present further evidence, which is also fine. If it is provided in advance, this should be provided in advance at the appropriate stage of the process. I would, however, say that parties are not required to participate in all of the inquiry or hearing sessions, and they shouldn't feel they have to. It's only where they feel they wish to make further representation within those processes. So I just going over that just to make clear, because there's a lot of people as part of this who may be unfamiliar. So hopefully that helps to clarify some of these matters. The whole process is designed to be fair and open, so everyone has access to the same information on which decisions will be made. While it may not always be necessary, parties should be prepared to take questions on their evidence from lawyers or representatives of other parties. So that said, having reviewed the submissions, I have set out in Appendix 1 my initial thoughts in regard to proposed further procedures. This reflects in part the position statements received from the main parties, in which there's been no request for inquiry sessions, and there's been a preference highlighted for going forward with hearing sessions or further written submissions. I just highlight that to note that's the position that has been set out. That doesn't preclude us with an inquiry session if we feel one is required. Whether the sessions will be held virtually or in person, we'll agree that at a later stage once we get an idea of what further procedures will be taking place. As part of the gathering of evidence, where relevant, I would expect a statement of agreement to be prepared. This is an agreement between the applicant and the council, setting out matters where there is agreement on particular areas. And I would normally expect that to be around the legislative policy context and the landscape and visual assessment elements to it. But that does not preclude a statement of agreement on other matters. The sooner that's prepared, the better for focusing down on the matters that remain of debate and dispute for any inquiry or hearing. We'll discuss timescales for statements of agreement as we go forward. So the focus for discussion today will be on the further procedure required, including site visit procedures. Further written submissions will be fleshed out and detailed requests set out in the minute of this meeting. Just to make people aware, the timescale for submission and responses to further written submissions or requests for these is normally 14 days for the submission from the issuing of the note of this meeting, with 14 days to respond. And again, the details of that will be set out in the note of meeting. And I would highlight at this point, I am conscious that there's a Christmas period that we'll have to take into consideration given the time of year and when this note will go out. So we'll take that into consideration if we're looking at timescales. I would also just like to reiterate that where no further procedure is listed for any topic in that Appendix 1, this does not indicate that those matters are not of importance. It is simply an indication that I consider that I have sufficient information in order to write my report to ministers. So finally, the fine detail of the scope of each procedure will be set out in the note of this meeting following our discussion today. So that brings us to looking at further procedures. Now, there's a lot of people here today, so we will take this at a pace that we can make sure that we're picking up all appropriate comments. So looking at the scope for further procedure, I'm assuming everybody's got the Appendix 1, and we will just kind of work through that in that order. And my intention is to go through with the applicant in the first instance, then with the council, and then with the other interested parties. So if we could start with the applicant looking at further procedure and Mr. Finlay.
So I know Mr. Henley's got his hand up, so I don't know whether he has
apologies.
Question.
Apologies. Yes. Thank you for that. Mr. Hindley.
Thank you. Apologies, this isn't quite the right time to raise this issue, but Stratherrick and Foyers Community Council takes the view that terrestrial energy out with the designated sites is worthy of further process. I noticed that your topic headings specifically only mentions within designated sites.
Okay, we can pick that up as we go through it. When I come to yourself about further procedure, if you can raise that point at that time, that would be fine. Okay, so is there any other hands up? Can't see it. Mr. Lumsden, I think.
Mr. Lumsden has.
Yes.
Hey, hi, sir. Just to let you know, I've joined the call. I was dialed in on the YouTube website, so I have seen everything that's been spoken about so far. So I just want to put my name forward as a resident on the traffic route, and I would like to speak when the time arises.
Okay, apologies for that if you were delayed in getting into the room, but thankfully you're with us now, which is good. Okay, thank you.
Thank you.
Thank you, Mr. Finlay, for raising my attention to that. I can now hand back to yourself, looking at further procedure.
So it may be, I don't know whether it's your intention to take it all in one go, but I was going to just make my points on the first item, which is further written submissions. We very much request a statement from Highland Council along the lines you've suggested, and indicate, and in our submission that should be provided as a matter of some urgency this side of the Christmas break. As to the second point you raised there, we are quite content to respond to Nature Scott's letter, and we would be able to do that this side of the Christmas break as well.
Okay, that's fine for those further written submissions. In terms of the looking at further procedure in the subject headings, can we start with that, and then we can pick up the rest of the further written submissions, if that's okay?
So in terms of the subject headings in our submission, legislative and policy framework is unlikely to need a hearing. The idea of having a statement of agreed matters is accepted and is sensible, but in our submission, the general background framework is very unlikely to be in dispute, and it would be quite capable of being dealt with by written submissions. And I understand that the Highland Council may also be of the same view in that regard. but I shall obviously leave Mr. Burnett to speak for them.
Okay, what I might do, Mr. Finlay, is just pick off these one at a time, rather than you go through every one and then come back, just in case there's any discussion, if that's okay. So, Mr. Burnett, on behalf of the council, just looking at the legal and policy framework.
Yes, sir. I would agree with Mr. Finlay that it's highly likely that there'll be a high level of agreement as to the background framework for the policy and legal issues, and it's unlikely to need a hearing session. Maybe that much of that can be covered in a agreed statement as well. So I don't think there'd be a need for a hearing on that topic.
Okay, thank you for that. Mr. Kelly.
I didn't want to unmute there. That's it now. That's fine. We want to be involved in the procedure. The board's approach to policy will be looking to provide the framework for their statutory objection rather than building a separate policy case as such. I could anticipate that maybe there might be some policy matters eventually raised in evidence, in particular evidence topics, but generally I would be happy with written submissions on policy.
Okay, thank you for that. Does anybody else have a differing view on how we deal with the legislative and policy basis, which would be through further written submissions rather than a hearing session itself? I'll just give this a minute or two just to make sure I'm picking up. We've got no hands raised, so I think we've got agreement on that. So people will be able to comment back on, if we go down this route, a statement of agreed matters will be produced, and I will allow sort of comments if anybody wishes to make comments on that once it's submitted, just so I've got a full picture. But that would be through further written submissions on that matter. Okay, that's very helpful. Coming back to yourself, Mr. Finlay, looking at landscape and visual impacts, can you give me your position on that?
Yes, welcome statement of agreed matters, which my understanding would be primarily between the applicant and the council on landscape and visual matters. In terms of providing further visualizations from Neil Fermini, the applicant is agreeable to that, and they're already in process. And I would hope they would be capable of being provided before the Christmas break as well. So unless we tell you otherwise, that would be the timescale in which they could be provided. As to the visualizations from the summit of Bena Baki, if I probably mispronounced that, in our submission they should not be necessary. There is a visualization from nearby Sui viewpoint, and the ZTV indicates that there will be only limited visibility from that location and no visibility of the powerhouse at all, which might be the prime objective of visibility. So for those reasons, at the moment, we don't agree to doing that, and it would take some significant time as we need to arrange new photography, which, as you can imagine, at this time of year would be difficult due to capacity and weather and lighting. So both for practical purposes and others, we don't wish to do that. If others wish to produce visualizations from the viewpoint or a wireline, no doubt they can do. And as to whether there should be a hearing, it's unlikely in our submission there will be a dispute on methodology. As to other matters, whilst there may well be a dispute in our submission, that could be dealt with in writing and by you undertaking appropriate site visits, having had the submissions. It's difficult to assess the need for a hearing in part due to the absence of any detailed exposition of the council's case. But in our submission, that can be dealt with by written submissions. But if a hearing, then save for my comment on methodology, I have no further submissions on the scope of the hearing.
Okay, thank you for that. Mr. Burnett.
Thank you, sir. I agree that the landscape and visual may well be capable of some further degree of agreement in a statement of agreed matters, and that methodology is unlikely to be a real issue. But I do think that there might be a need for a short hearing in relation to matters that remain outstanding at the end of that process. But by that time, it should be focused on one or two areas rather than requiring a large degree of time at any hearing. And welcome the visualization that's going to be prepared. We would prefer the further visualization from Ben Beich, but that's really a matter for the applicant, whether they're prepared to do that or not. And we may be able to come to an agreement in the statement of agreed matters about that as well.
Okay, that's very helpful. Thank you for that. We'll just go back to Mr. Kelly.
Thank you, sir. The board would wish to take part in the written exchanges on landscape and visual impact matters, but again, by way of providing context for their statutory duties-based objection, we think it would be worthwhile, particularly in terms of views from the Loch, allowing time in the schedule for a short hearing on LVIA. But of course, nearer the time, sir, you could come to a view as to whether it is actually needed or not once the written exchanges have been completed. But I think it would be worthwhile allocating a short period of time when you think ahead towards the in-court hearing date and the schedule for that. Thank you.
Okay, thank you for that. Just at this point, what I would say is that because we require the inquiry statement from the council and we don't have the sort of full sort of reasoning behind the objections from a landscape and visual impact, my insight would be to programme a hearing in so that we've got it there if we require it. And we can obviously review that as we go along through the various stages of the process. But if we put the provision for a hearing in now, then that allows us to have that there if and when required. So that's my kind of initial thing, primarily because we haven't seen the council's full sort of reasoning behind that. Taking that in mind, is there anybody have other views on that particular matter in terms of further procedure? If so, please raise your hand. Okay, I'm not seeing anybody raising any hand. If I miss somebody, please draw my attention to it because there's a fair number on screen and I'm trying to do that. But no, I think that's fine. Moving on to the next item, looking at the terrestrial ecology in terms of the designated sites, I take on board the comment made by the applicant in terms of the agenda note for the River Morrison, which is the correct title, SAC, wouldn't fall under this particular terrestrial ecology. That would fall under the aquatic ecology in terms of designated sites. So that was my error, including it at that point, and it should be under the other item. So in terms of looking at the terrestrial ecology and designated sites, Mr. Finlay?
So in our submission, at present, there's no need for a hearing, given in particular Nature Scott's position that they are satisfied with the derogation case. We obviously haven't had the council's detailed submissions yet, but given Nature Scott's position, which is in reality one of non-objection, and the lack of any detailed submissions on by other parties, in our submission, at the most at this stage, there should be a written exchange insofar as it's necessary, with the possibility, which we think is unlikely, of a need for any further hearing.
Okay, thank you for that. Sir Burnett and Council.
Yes, sir. I think it would be sensible to schedule a hearing session for this topic as well, although there's likely to be a degree of agreement again. I think the Nature Scot position in relation to the next wood SAC is they would object and need the derogation, and therefore it is an important issue that may require you to hear evidence at a hearing or further comments on that issue at the very least, and therefore it'd be sensible to schedule a hearing at this time, although the scope of that hearing could be cut down after an exchange of further correspondence and or an agreed statement of facts and agreed matters.
Okay, so are you looking at potentially a statement of agreed matters on this subject as well as the other two above?
Yes, in advance.
Thank you for that. I won't go to Mr. Kelly directly this time because this is a broader subject. If you can raise your hand if you want to comment on this, then please do so. I've got Mr. Hindley first. Mr. Hindley.
Thank you very much. Into the case for derogation, Stratherrick and Foyer Community Council takes the view that hearing in this respect is necessary. We learned that the step one, the assessment of alternative solutions, the case is not completely made there, and that needs further work.
So do you wish to have the opportunity for further discussion on it in terms of a hearing or written submissions? What, yes. In terms of procedure?
Yes, that's correct.
Both or just one?
Sorry. Case, yes.
Right, okay. Let me just check. Mr. Sanderson, I think you've got your hand up. If you'd like to speak next.
Yes, thank you, sir. Yes. British Lichen Society certainly considers it should very least go to a hearing session. With the Natural England, Nature Scot are not accepting that there is no damage to the SAC. And we've got pretty technical evidence based on EU legislation, which we think should be at very least hearing. I'm happy for it to be challenged in cross-examination, but we do think there's a serious case to discuss.
Okay, thank you. Anybody else wish to make any comment on this? Mr. Kelly?
The board has an interest in this and would be happy to follow through with written submissions and then see where that goes in terms of a hearing. If a hearing takes place, then we would be present. Can I just make one point, sir, I think at this stage in relation to the way the discussion's been going? The council and the applicants have been talking about statements of agreed matters between them in relation to multiple topics. From my client's perspective, and as set out in the email from me, which you have, sir, we would prefer to see written submissions and rebuttals so that all matters under each topic are addressed, if they wish, by parties. I think that if you're presented on multiple topics with a statement of agreed matters between the council and the applicant, it could limit the scope of evidence for others. So we would prefer to see for these topics hearing statements followed by rebuttals, just as set out. But otherwise, for this procedure, I have no dispute with what's being suggested, written exchanges and then a hearing.
Okay. Mr. Findlay, you've got your hand up, I believe.
Yes, so thank you. In respect of Mr. Kelly's last point, in our submission, a statement of agreed matters is an entirely useful document to have, irrespective of whether one is going to proceed to a hearing or otherwise. Certainly in the policy provision, you've made express indication that Mr. Kelly should be involved in that process. We're content for others to be involved in the process in terms of other statement of agreed matters, although it's tends to be, as a matter of practice, easier to reach a stage of agreement or disagreement with the council first and then put it out wider. But the main reason for raising my hand was that at present, although parties have said the topic is one of importance, in our submission, nothing has been raised with you yet or identified which would justify a hearing at this stage. So whilst in our submission that we don't rule out completely the possibility of a hearing, it seems unlikely, but the first step should be to require parties who are suggesting there is further information to be provided on this issue to provide it. So written submissions should be the first step, without ultimately a hearing programmed at this stage.
Okay. Anybody else? Any comment? Again, with this particular matter, we obviously don't have the council's full sort of reasoning on this matter either, and this does constitute one of the reasons for objection to it. I'd prefer to be prepared, and therefore I think at least programming a hearing in if required. If we get to a stage where it's not required, that's fine. But I think at this stage, I would prefer to have it there and then not to use it rather than to scramble about. The other thing I would say, in terms of just for other parties, the statement of agreement that we would be looking for, where there's a hearing, does not sort of curtail your ability to put whatever you wish in your hearing statement going forward if a hearing statement is there. So it's helpful to the council and the applicant and to myself to narrow down where the areas of dispute are. And I think that's the key thing for a hearing or any further procedure, is to find out where the areas of dispute in principle are, so these can be given a good examination for that process. So, as I say, the statement of agreement is just part of that. It doesn't curtail any further procedure if required. Does anybody else have anything else to say on that terrestrial ecology at this stage? So, moving on to the next item, which is traffic access and transport. Mr. Finlay, again, we'll just start with yourself.
In our submission, this could be dealt with by written submissions. Obviously, parties have concerns about it, which is why there are a number of local residents here today on the call, but there's been no objection from the council's relevant department, and it's in our submission, this is a matter that can, if parties do have additional concerns that haven't already been presented in writing, they can be done in writing, and it be a matter that can be dealt with through written submissions.
Okay, thank you. For the council.
Well, sorry, again, I think it'd be useful to schedule a very short hearing session on this. I mean, the council's department did have concerns about this, and no formal agreement has been reached as to the mitigation measures that might be introduced to allay that concern. It may be that further progress can be made in writing, but a very short session of the hearing, if there is going to be a hearing, should, I think, be set aside for this topic as well, and also considering the high level of local concern about this issue.
Okay, thank you for that. Now, I did see a hand up. We'll start with Mr. Hindley, because you would put your hand up first.
In relation to roads, the view of residents is that all the local road network is classified as a B road network, considering the capacities of that network without seeing those and experiencing them leads to inadequacy of their capacity and ability to sustain the traffic that a development of this sort would necessitate. So we would ask that there was actually a site visit to inspect those roads and view in person what they're like.
Okay, thank you for that. I'll just pick that point up now. I was going to do it later on. It would, given the level of concern that's been raised in terms of the impact on the local road network, it would be my intention to do a site visit of the route. Now, I'm conscious that it might be one of these things where it's because of the sort of scope and ability to stop and park, etc., that might have to be done sort of carefully. But it would be my intention to do that unaccompanied. But if parties felt that an accompanied site visit of certain parts of the road where there are concerns, then that would certainly form part of an accompanied site visit. And I would maybe get either the council in conjunction with yourself to actually put an itinerary together of the areas that you had greatest concern, so I could actually see them for myself. Because I think with these kind of matters, seeing it physically is important for me to fully understand the concerns that are being raised. So is your main point in this to actually have the site visit, that rather than looking at sort of further procedure in terms of a hearing, or just to clarify what your position is on that?
I'm grateful to hear that you intend a site visit. I think very useful, but there are considerable concerns that the baseline data that's presented by the applicant is not entirely believable, and therefore all of that information needs to be scrutinised, and I think that needs doing through in addition to the site visit that you would undertake.
So you're looking for requesting a hearing then for this subject, yes? Okay.
Yes, please.
Okay. And Mr. McLeod, I think, is next on my list.
Yeah, thanks very much, sir, for that. Yeah, we've done a lot of work with Scottish Canals and also engaged with Highland Council about how we can mitigate the amount of usage of the rural roads, which is of great concern in that area. And from that point of view, we'd be happy to, do a written submission of how we see a waterborne solution helping to alleviate some of the concerns and issues that are being raised about the road network. But likewise, I can understand from a community perspective that they would like to see a hearing to discuss that, and we'd be happy to take part in both. Thank you.
Great, thank you for that. And now somebody else had their hand up. Mr. Lumsden, did you have your hand up, I think?
Yeah, thank you, sir. Yeah, I would like to second Mark's proposal for a breakout on the traffic discussions. I'd like to understand what the real mitigations will be on the route, because they're not clear. I'd like to understand the reasons for the route that's been chosen, and certainly an assessment and a site visit to the actual proposed route. I would second that.
Okay. Who have I? Maria Coburn, I think you had your hand up. Yes.
Yes, thank you, sir. I did. And Strathnairn Community Council notes your intention to carry out site visits, and we thank you for that. And we would also second Mr. Hindley's nomination for a hearing to that end. In addition to the aspects that you've already mentioned with regard to the site visit, I know that you've outlined areas that you will look at on an individual basis, but I think it's very pertinent to consider the impact of noise and vibrations inside individual dwellings and schools, because they are roadside, and also to take into account the fact that weather and conditions affect driving. For example, We have wintry, icy, snowy weather right now. It's an unclassified road, and in the summer, drivers for a significant part of the roadway are driving directly into the sun in a southerly and to southwesterly direction. I think that needs to be factored in, bearing in mind the time of the year that we are now. That might not be possible to do a summer site visit, but it should be borne in mind in planning that.
Okay, that's fine. And now do I have, is there anybody else? If there's anybody else, please come on screen now that would like to comment.
Hello, can you hear me?
Oh, right, sorry, yes, got you. Yeah, you've now appeared. I heard a voice, but now you've appeared.
Hello, sir. To add to the site visits, I think it's very important that the time of day as well as the time of year is selected carefully for these, because there are 12 settlements across the B, 851B, etc., through from Strathnairn to Stratherick. 12 small settlements that are strung out, which feed to primary schools. That's 3 or 4 primary schools and also an academy with school collections and pickups and drop-offs from the road. So the timing in terms of the site visit is also very important.
Okay, that's fine. My intention would be to allow either the council or the council with the interested parties to prepare the itinerary. So it would be for you to set the times, the locations, etc., that you would like me to visit that. So I would go on the basis of what you would consider attention. So I won't set that and a particular time, so that you would have the opportunity to build that into an itinerary for any site visits that you wanted to.
Thank you.
Okay. Anybody else? I think all hands down now. Okay, I think again, we've still got to wait for the council's more sort of detailed sort of reasoning behind their reason for objection in terms of the road network. There is obviously a lot of interest in the impact, so my tendency would be that we do the further written submissions, responses to anything put forward by the council in their inquiry statement, and I think we'll programme a hearing in for this particular matter as well as a site visit. Okay. Anybody else, any comment on that one before we move on? Okay, right. Moving on to the next items, I think the ones we've touched on there are some of the ones that have raised most concern. Socioeconomic benefits, my basis for that is that if anything, no further procedure would be required on that unless anybody is in disagreement. Obviously, we've got written submissions to pick up. Anything else? But does anybody else have a view on that particular? I've got hands up by Maria Coburn and do you wish to, is this for this matter or is it just a hand not going down from previous?
My error, so I didn't turn the microphone off.
That's okay, I just didn't want to miss. Okay, so in terms of socioeconomic benefits, Mr. Finlay, anything to comment?
No, there's no need for, I don't think there's a need for any further procedure.
Okay, council?
Yes, that reads, sir.
Okay, does anybody else have anything to comment that's not already been written down and is already before me in writing? Okay, moving on to water management. Now, I think, Mr. Kelly, you had sent an email prior to the meeting today. I think looking at water management, aquatic ecology and fish, if I've got that correctly, would you like just to put forward what you've indicated with regards to these matters, just so that other parties can hear it who haven't read your email?
Yes, sir. So far as the board's statutory duties and interests are concerned with this case, the matters of water management, aquatic ecology and fish all overlap into their statutory duties and functions. So in the email that I've sent to you and copied to the council and the applicants instructing solicitors, I've suggested that these three topics be taken as a single topic, that there be written exchanges in advance, and that there should be a hearing session set aside for these three combined topics. Also, it remains the position of the board that they will be looking to challenge the position of Nature Scott, particularly section 2 of their most recent letter to you. And in that regard, the board's position is that you might well find it helpful for Nature Scott to be present at that hearing session, since the board will be somewhat significantly challenging the Nature Scott position. So in summary, sir, the board is looking for the three topics to be taken together and addressed by written submissions and then a hearing. Thank you.
Okay, Mr. Finlay, would you like to respond to that?
Yes, our initial position is that both SEPA and Nature Scott are not objecting on any of the topics Mr. Kelly's raised. We provided a very detailed response to the NEST board in our updated position statement, to which I understand there's been no response. We understand these are positions of NEST board's responsibilities, but just because it has a responsibility on a particular issue doesn't give rise to the need for a hearing session on any of them. We have no detail of the NEST board's position, at least its most recent position, and if there is to be any further procedure on these, aside from the reference from the further written points you've made in respect to SEPA and the Scottish canals, then it should be by way of a statement from the NEST board and or the Highland Council setting out whether there is anything substantive to be dealt with at all in our submission. They can both adequately be dealt with, as I think you've suggested, by further written submissions at this stage, and there is no basis for programming a hearing. It looks likely that there will be some form of hearing at some stage. If a further short hearing is needed to deal with any points, then no doubt that can be added. But at this stage, given what I've outlined in our submission, there's no basis for a further hearing. But we would wish to know precisely what the NEST board wish to advance. And lastly, in our submission, it's a matter for Nature Scott whether they wish to appear, but there's no need to require their attendance or even their input at this stage, given the input they've given.
Okay, thank you for that. I'll come back to you, Mr. Kelly, just once I've been round other people. Mr. Burnett.
Yes, sir. This is not a matter on which the council would seek a hearing, but recognising the responsibility on the Fisheries Board. If you decided to have a hearing, I think the council would wish to attend, to have a watching brief on that, not least because it may have repercussions for conditions or other matters, but we wouldn't seek a hearing on this matter. It's not a major plank of the council's case.
Okay, thank you for that. Mr. Kelly.
I understand Mr. Finlay's wish to see an updated position, and certainly in terms of the written submission that I had envisaged for starting off on this combined set of topics, the board would summarise the objections made to date. It would address the applicant's position statement, which was quite detailed, and it would also address the position, respond to the position of Nature Scott in terms of their October letter. So by the time, by the deadline you set, sir, for the first set of written submission exchanges, the board's position would be set out in full and the applicants would be able to respond to that. So certainly, sir, the board understands the need to set out the case in full, but at the moment, so far, you've not actually set any dates for that to be done, but we will do that.
Okay, thank you for that. Does anybody else wish to make any comment on this particular matter? Okay, I'm not seeing hands up. What I have included as further written submissions is requesting the board to respond to the applicant's position in Annex B of the submission, which I think would be helpful because that's their response to the concerns raised. And that would then, perhaps through that process, help to narrow and clarify what the main grounds of objection are. What I would propose, because it's obviously it's an important matter, that we would pin a hearing there if required, but again, I think that would be reviewed at the point once we have a response to that initial further written submission, and then the applicant's opportunity to comment back to that. That will give me a better idea of what further information I think I might require as a result of that process, and that will also give the full opportunity for the board to comment on the applicant's response in that. So I think that's where both parties were trying to get to as a starting point, and I think we could do that through further written submissions, and then at that point I would be of the mind to then view whether I consider whether anything else is required in terms of a hearing. But what I would do is just again, I don't think any of the hearings for the matters are likely to be sort of lengthy sessions. The traffic one may be longer because there may be more participants, but I think again, just penciling in a short hearing at this stage to pick up any of the matters that remain and I require any kind of clarity on would be my current thinking on that matter. Mr. Kelly.
So that's fine. I can confirm that the board is very much wanting to assist you by focusing onto the key areas of disagreement between them, the applicant, and Nature Scott. There is no, we do not envisage any need for a lengthy, wide-ranging hearing session. I mean, you've mentioned times later on. I mean, less than half a day, a couple of hours would be more than adequate if you needed a hearing on this topic. But I'm content with what you're suggesting, sir.
Okay, just coming back to Mr. Finlay, do you have anything else to add at this stage?
No, I'm hoping we can dispense with the need for any form of oral session, but I'm grateful that Mr. Kelly, on behalf of the board, recognises that the next step is in its court, so to speak.
Are you also happy that you go with the grouping of those three topic areas into the one response?
Yes, insofar, absolutely. I mean, it seems to be we'll have all the relevant parties together that wish to be there, and it would seem to be insofar as there need to be any further procedures, it would be sensible that they're all dealt with together.
Okay, thank you for that. Does anybody else have any comments on any of those matters before we move on? Seen any hands up? That's helpful. I think in terms of the next ones from the geology, soils, water peatland down to forestry commercial, although there's some further written submissions on the geology, but the remainder of those areas, I think I'm not seeing any required for any further procedure on those. I've got detailed submissions from parties on all of those. So do any party wish to have any further procedure in any of those matters running from on the appendix from your geology, soils down to forestry commercial? Not seeing any hands or head shakes. Okay, moving on then to planning conditions. Obviously, we were looking for further submissions in terms of planning conditions through the normal process of the applicant preparing a draft list and the opportunity for comment on that. Mr. Finlay, any views on whether you think we should pencil in a hearing at this stage in case it's required? We may well, of course, resolve most of the matters prior to that for conditions, but we normally kind of just reserve something just in case there's areas we need to just investigate a bit further.
Yes, if there are going to be other hearing sessions, there's no harm in identifying a short hearing session. It's likely to be very short, I would hope, but with luck and goodwill, hopefully most of the conditions, if not all of them, will have been agreed in advance.
So,
yes, sir, I think it would be sensible to schedule a conditions hearing session, but at the end of all other hearings, and would expect there to be an agreed draft of conditions at least to comment on, and it may be that through discussions at other hearing sessions they may need to be tweaked, so there may be a need to discuss that after everything else is heard. So it'd be sensible to schedule that at the very end in case it's needed.
Yeah, that would be normally where I would organise that as the last hearing session for those reasons, so I have no issue with that. Does anybody else wish to comment on conditions, Mr. Kelly?
Yes, so the board would like to be involved in the consideration of the draft list of conditions in case there's any matters arise in relation to its interests. And I would agree with the point Mr. Burnett has just made, that it's possible that from matters arising in the other hearing session, particularly in relation to the board's interests, it might be necessary to tweak conditions. So to have a short hearings session scheduled, I think would be a good idea.
Okay, thank you for that. Does anybody else have any other questions or comments? Okay, so I will now try and summarise where we've got to on this particular stage where we're thinking. So just going through the table in Appendix 1. In terms of legal and policy, we've agreed for further written submissions and no further procedure beyond that. For landscape and visual, further written submissions and penciling in a hearing session if required. Terrestrial ecology, again, further written submissions and a hearing if required. And transport access, again, the further written submissions and a hearing if required. Then we're looking at grouping together water management, aquatic ecology and fish for further written submissions and penciling in a hearing if required. And finally, looking at conditions, further written submissions and a hearing penciled in if required. So that would be looking at penciling in 5 potential hearings, some of which may take place, some of which may not. And that, does anybody, and looking at, we'll pick it up just now, looking at site visits for the transport access and transport. I will also carry out site visits of the landscape and visual impacts of the site and the wider area. And when I come on to looking at the site visits itself, I think it would be useful if the applicants could arrange a visit around the site itself where possible in terms of the access roads and vantage points within the estate, rather than me just wandering in and causing chaos or havoc by turning up. So if I can pick that up at that stage, that would be helpful, just so I can actually get sort of access into those areas.
That's noted, sir, and I'm sure that shouldn't be a problem. No doubt that there'll be liaison about that in the usual way.
Okay, thank you for that. Does anybody else have any comment on any of those matters? Okay, Mr. Hindley.
Thank you. Just to go back to the point raised earlier, which I don't think we've quite resolved, about terrestrial ecology out with designated sites. So we don't have a topic area that would be covered in. Would you be prepared to consider alongside the terrestrial ecology in designated sites? It's particularly relevant for lichens, where the applicants' surveys found previously unrecognised sort of lichen in and around Loch Kemp, but outside the designated areas, consideration of terrestrial fauna, terrestrial ecology outside designated sites is important.
I think if memory serves me right, and please correct me if I'm wrong, but I think the EIA looks at sort of the wider area. The reason I designate sites are there because that's the focus, perhaps, of the impacts of that. But it's up to yourself if you want to include further comment on that within any sort of hearing statement or whatever you submit or responses. Then that's for you to do that. So that's not ruled out by just saying sort of designated sites on this element. If you want to have sort of a wider submission of that, then that would have to be within your either full written submissions or in any hearing statements, so that the other parties can get clear sight of it in advance of any further procedure.
Okay. Because the topic title isn't excluding us making a submission in that area. That will be fine.
No, because the title heading should be terrestrial ecology. The designated sites was just to emphasise that's the sort of the focus of the disputes that were there, but it doesn't mean there's not other matters that are around that. Does that clarify? Yes.
Thank you.
Mr. Sanderson.
Thanks. I know that clarifies it. Just to say that we had actually commented on the non-SSI terrestrial impacts on our initial evidence. So we'll be taking advice on what we put in written submission, but we have commented on it. So
thank you for that. That reassures me, because I'm in my head I thought I had read that. So it has actually been in there. That's fine. And Ms. Coburn, oh, your hand's gone down now. No, it's up.
No, sorry. So can I just clarify whether noise and vibration would be factored in as part of a site visit when looking at traffic?
If you're looking at traffic, then you can include that. There's obviously a separate thing about noise and vibration in terms of construction. If you're looking at purely anything under traffic, we can look at under the traffic access and transport heading.
So.
Okay, so yeah, moving on to, I think, item 7. Is everybody happy to carry on, or does anybody need a short break? I'm happy enough to carry on, but if anybody feels the need for a 5-minute break, then we can do. Or will we press on and get through things? I'm seeing no hand up for a break, so we will carry on. Item 7 is looking at participation in further procedures. I think I'm quite clear of what further procedures we've put in place, and who has indicated an interest sort of in that, and that's very helpful. Looking at the timescale sort of for each session, I'm just going to propose something to you, and then you can just maybe see if I propose something, and then you can respond back to that. But looking at the provisional times for sessions, and I'll just do this in reverse order. I would be thinking provisionally half a day for planning conditions would normally be sufficient, even if it's required sort of for that. But we can put in an AM or a PM session for conditions. Does anybody have? Please chip in if you don't agree. That would be the way we'll move forward.
So I would suggest at this stage that given it's likely to be less than half a day, it would be. I mean, I'd have thought you could programme, given where we are at this stage, and we have I think a fairly full set of conditions in the Highland Council report of handling as well. We're likely to be in the position of being able to deal with that within an hour or so. But
okay, does anybody have a difference of opinion on that? My normal position, I would normally put at least 2 hours, because with the best will in the world, it's better to finish early rather than to end up squeezing sort of time. So I think I prefer to be slightly cautious rather than optimistic in timescales. But what we'll look at is what we can maybe fit into a day session overall. So because looking at what we've got there, I'm initially looking at this potentially maybe 2 days to get through the hearings that are proposed. And I don't know whether that number creates any initial sort of concern by parties.
so, I mean, in overall terms, I think 2 days would be a reasonable time estimate for all oral procedure, as given there's a certain amount of ambiguity as to the extent of it. But I think 2 days should suffice. And my understanding is that that is possibly the position of Highland Council as well, just judging from how these inquiries have gone in the past.
Okay, Mr. Burnett, you can speak on behalf of Highland Council, of course.
Yes, sir. I was going to say, given the number of topics, it might spill over into a third day if you were being cautious, but I suspect that some of them will contract, and therefore an overall period of 2 days should be sufficient for everything, on a rough rule of thumb that they will average half a day and there'll be some extra time left over. So I would have thought 2 days should probably be enough, with good direction and focus, which may increase with the further written submissions in one way or another.
Okay, Mr. Kelly, we'll just go to yourself next.
Yes, I would have thought, I'd agree with Mr. Finlay. I think 2 days maximum would be needed, especially if we go through the clarification of issues through the written submissions and statements of agreed matters, if you have suggested. I don't know whether this is the appropriate stage to raise it or not, sir, but one of the reasons why I had suggested virtual hearings was that I had envisaged that the various hearing sessions would have core representatives, but lots of other representatives who would change from hearing to hearing, and combining that with focus. The feeling of the board was that we could proceed by way of virtual hearings, which seemed to work quite well in other cases, but obviously that's a matter for you to consider, sir, in the live discussion today.
No, we'll come on to the format once we've agreed the timescale, Mr. Kelly, but that's helpful. Does anybody else have any sort of views on opinion? And I appreciate that if you've not been involved in this process before, then it's going to be difficult, but has anybody any further comments they wish to make? What I would say is that my aim would be that everything was given proper sort of time and scale for airing the matters, but what the further procedures are there for is to really focus into where there are the remaining areas of dispute, rather than going over the case, because I've already got all the written submissions and I'll have gone over all that in detail. So everything that you've provided so far will be taken into account. So the hearing is just to test and tease some of those areas of dispute that I require further clarification on. So that said, Mr. Lumsden.
Yeah, thank you, sir. Just my concern or point to make would be regarding the assessment of the traffic routes, really. So, because there's essentially
just to sort of clarify, apologies. That timescale does not include any of the site visits. Okay, that would just be for the hearings themselves. The site visits will be a separate matter and may take a whole day. We may time the line. We may take the site visits for the transport and my site visit onto the site itself as a whole day element to it. But yes, the timescales we're talking about are only for the sitting and hearing of evidence, not the actual site visits itself. So that said, I'll let you carry on.
No, you covered my point. That was my concern. If it was to assess the different traffic routes, then it would, yeah, I mean, take up the full day. But no, you've answered that. Thank you.
Okay. Mr. McMillan? You're still on mute. Thank you.
Okay. Yes, there seems to be no consideration made for tourism and the tourist economy in this meeting. It's a massive part of the Scottish economy as well as the local economy. Statera plan to raise the loch by a level of 1.57 metres every 24 hours over a range of 2.07 metres. I think it's going to have a huge effect on the tourism well-being of the area and the international draw that Loch Ness is to Scotland. And I think it's a very important issue that should be fully discussed.
Okay, what I would say is that we're not covering it. It is down there, the socio-economic benefits. Although it says no procedure, that does not mean it's not being taken into consideration. Obviously, that's been looked through in the submissions. It's also been raised in representations. What really I'm saying is that I have got what I consider to be sufficient information from what's been submitted, written down that there's no sort of remaining areas that require further procedure. Further procedure, as I said at the start, does not in any way indicate the lack of importance or attention that's given to subject matter. It's just where further information is required, or where I need to get to the bottom of maybe disputes between two parties.
Okay, can I just add though that Statera have been very reluctant to give out actual information of the water levels. And I had to go to my MSP and they had to ask several times to get this information. So I don't think it's actually, excuse me, very well known. And I hope it is.
Well, what I would say is that the matter you're referring to, although it has a tourism impact, if you're talking about water levels, that's under the water management. And obviously we are looking to have potentially further written submissions and a hearing potentially on water management. So those aspects have been submitted, are part of that process with that. So hopefully that reassures you that that would be considered obviously under that heading. So if you wish to comment on those elements then, or participate, then you can obviously do at that stage.
Okay, thank you.
Okay. I've not seen any other hands up. So if there's no further comments on that, what we'll just need to establish is who's fully participating in each session. So as part of the PM note of the meeting, I will be asking people to confirm what of the proposed sessions, except that they will be participating in. So moving on to, I think, unless I've missed anything, they're looking at the dates, item 8, dates, location and likely overall duration of the hearing inquiry sessions. I had initially put round looking, given the timescale for doing the written submissions, taking Christmas out of the equation for responses, and then hearings if we need to have hearing statements submitted, etc. I was looking at the week commencing the 23rd of March. We wouldn't sit on a Monday if we were doing in-person hearings. We would be starting on the Tuesday. So with that in mind, can I go around the parties in terms of availability timescale? Mr. Finlay.
So we have availability difficulties and wouldn't be able to attend on the 23rd of March. We've suggested the last week in February, 24th and 25th of February. I think there's been some correspondence about that for the 2 days. Alternatively, the beginning of April, let me just confirm that date. In and around obviously not the bank holiday Monday, but there's the week of the 7th of April. We do have one we have a transport witness who may have difficulty in that week. If we could get the week, that would, I think, be our preference. So the 7th week of the 7th. Well, our primary preference, because of the matters of urgency which we've raised before and canvassed in email in our position statement, would be to aim for the end of February, but our fallback position would be the beginning of April.
So is it that whole week in April then?
Yes.
Yes. Okay, that's fine. Okay, council.
Unfortunately, sir, the council's fully available the week of the 23rd that you identified, and the following week of the 30th of March, up until obviously Good Friday. On the Friday, not available, but 2 days before that. But the week of the 6th of April, we do have a participant in relation to a landscape and visual who would be unable to attend because it's Easter holiday. Available the following week, the 13th of April, anytime, and I think the week after that, the 20th of April, apart from the Tuesday, the 21st. So that is the council's position. I mean, we might be able to attend on the week of the 23rd of February, but really do feel that that would not give adequate time for everyone to prepare for the hearing, given the number of issues that have to be covered by everyone and the interruption of the Christmas period. The council's offices are closed for full 2 weeks over Christmas, and just think it might lead to difficulties with everyone's availability if it were to be at the end of February.
Okay, so can I just clarify then, in terms of April, you're looking at the week beginning the 13th?
Yeah.
Or the
20th, but not, it'd have to be the Wednesday, Thursday, Friday, rather than there's a difficulty on the Tuesday only.
Okay.
And you do the final week in March rather than Good Friday.
Okay.
We can do the whole 23rd as well, week 23rd of March.
Okay, Mr. Kelly.
We have not seen these dates before, and have not been circulated around to parties in advance of the meeting, so I don't have my client's instructions on the alternative dates. We were available the week beginning 23rd of March. I tend to agree that the February dates would be rushing things far too much, given the Christmas break and the various submissions that have to be done. Going into April, I'd need to check with my client, but provisionally, any of the weeks in April that have been mentioned are possible, but we should bear in mind that Scottish ministers are currently indicating that the public inquiry into the Spittal to Loch Kemp to Bewley overhead line section 37 application would commence on Monday the 20th of April. So we would want to have this case completed before then. But the week of the 7th or 13th of April, we could probably do, subject to me checking with clients, but to repeat the February date, I think is too early, sir.
Okay. Does anybody else have any views on those matters?
So if I could come back.
Yes, surely, Mr. Finlay. Yeah.
The week of the 13th of April is, if we have to go that far back, is one that my understanding we could do, and indeed my transport witness would be available, save on the Monday of that week.
Okay, that's very helpful. Thank you for that. That's the week commencing Monday the 13th, or Tuesday the 14th, we'll call it.
Yes.
for going forward. Okay, Mr. Sanderson, you put your hand up.
Yeah, and well, thank you, sir. Yes, we'll obviously in fit round what everyone else's timetable is as far as possible, but we would find people far too early, I'm afraid. We wouldn't really appreciate that.
Okay, I'm seeing no other hands up at the moment. So I think the week that most people seem to be available is that week commencing Monday, the 13th of April. I would agree that I think the February date is a bit tight to get down, and I don't think that that week would particularly suit myself, so I would prefer to avoid that. If there's nothing in that later part of March, then unfortunately, then I think it does push it back to that April date. What I will need to confirm is availability of sort of webcasting within the DPA for that particular session, but we can pick that up. If we're based it on that week, the second part of it is whether we think the hearing sessions should be in person or virtual. Mr. Finlay.
We have no particular view. We would be content with either, but if it was to be in person, then would agree that it should be local to the area, whether that be in Inverness or in Fort Augustus.
Okay, thank you for that. The council?
Again, we have no strong views on the matter, sir. As long as it's available to the public in one form or another, it's a matter for you which you think might be more efficient or suitable.
Okay. Mr. Kelly, I think you've already indicated virtual, unless there's a different position.
No, sir, we prefer virtual. If you wanted to have in person, then we would suggest Inverness for the convenience of parties and accommodation facilities, etc. And just to pick up on the previous item, sir, I've had an email from the Chief Executive of the Board saying that the week of 13th February is fine.
13th of April, sorry.
So April.
Yes. That would be even earlier. I don't think we want that one.
Apologies, sir. No, April. The April date you're looking at would be convenient for us now fully. Thank you, sir.
I would welcome any views from the other participants about the convenience of virtual over in person from your positions. Mr. Hindley.
I think there is within the local community that in-person in this area would be preferable.
I just clarify, when you say in the area, is Inverness in the area, Fort Augustus in the area? Obviously, we need to have a facility that's accessible, that has the ability for us to broadcast the sessions, so that we've got them webcast as well. So what would be your view on within the area, just to be clear?
From Whitebridge, both Inverness and Airways. So we have a fine public hall in Whitebridge and Gorthlake that have facilities, and if they were physically large, we could certainly explore the possibility they would be adequate for your requirements.
Okay, so that's, I can get any details from you in terms of facilities to check those out. Okay. I think my kind of feeling, given the sort of level of sort of interest that's been shown in the application from the local area, would be to do the hearing sessions in person in an appropriate sort of place locally, and there doesn't seem to be any strong sort of objection to do that. Mr. Finlay, did you want to say something? Sorry.
No.
So I thought you were reaching to press your microphone there. My apologies. So I think, Mr. Kelly.
Again, we can make other comment in response to the meeting, but would you consider hybrid hybrid approach to the hearings to accommodate both local people and experts and others from disparate areas?
It's an option, but it would be dependable on the facilities for the someplace we went. So I'll pencil that in to have a consideration. Have you got a number of witnesses that you wouldn't be able to attend in person? Is that what you're alluding to?
No, your colleagues may know my position from other cases. It would only be the chief executive and myself. It would, and I can explain it in a private email via Laura, sir, if it would help. I prefer it to be Inverness. If it's in person, I prefer it to be Inverness.
Okay. Sorry, somebody else had Mr. Prendergast. You've got your hand up.
Yes, I was just putting my hand up in support for an in-person meeting if possible.
All right. Right, that's noted.
Okay, thank you.
That's okay, that's no problem. Mr. Sanderson, you've got your hand up again, yes?
Yes, thank you, sir. Yes, just say we would prefer in person if we're going to be guided by your decision.
Okay, that's helpful. Thank you for that. Okay, so provisionally, I will check with my IT support, but provisionally we're looking at that week of the 13th of April, a 2-day session. The Tuesday and the Wednesday, does that suit people? Because if it gives us a bit of fallover if we have to kind of move on to the next day. If we have to move on to the next day, then it might be that could be done virtually if we sort of run out of time in person. But so that would be the 14th and 15th of April. Mr. Finlay?
Yes, that seems appropriate. Thank you very much.
Okay, Council?
Yes, that should be fine. Thank you, sir.
Mr. Kelly?
Yes, sir, fine.
I'll come to you, Mr. Hindley, because you've been doing most of the talking, so that's that okay with you? Yeah. And Mr. Sanderson, you're okay with that? Yeah. Okay. I'm not seeing any hands up from anybody else, so I'll assume silence is agreement with that aspect. With the venue, we will have a look at accessibility for all parties. So if there's any issues with accessibility, please write into the case officer explaining the reasons why, and we will obviously take that into consideration to make sure that everybody has fair access to it if it's in person. Okay, so site visits. As I said, I will carry on unaccompanied site visit of the locations that are part of the landscape and visual thing. I think I can see most of those from public vantage points as far as I'm aware. So I will do that. The accompanied site visit of the traffic and transport on the road, I would request that the council, in coordination with the community council or the appropriate people, would put together an itinerary. It would be helpful for me if I was up to do the site visits the same week. So that would be probably the 16th of April, if that's possible. And if we could include, I know that the nights will be getting slightly longer by then. If we can do the site visit around the estate, if the applicant could organise that. So if the applicant and the council could coordinate either a morning session on the roads and an afternoon around the estate or vice versa. If it's too tight to do both, then I would be happy enough to do a morning session on the Friday. So if the Thursday was dedicated to the transport and access, if it needed that, then that's fine with a half day around the estate. Both of those would be accompanied, so people can attend those if they wish. If they wish to, then need to make that known so that we can organise the itinerary for those days. Mr. Kelly.
From the board's perspective, they would ask you to take an unaccompanied site visit, a boat trip on the loch, using one of the cruise boats to look at the power station site from the loch itself. Obviously, we don't all want to pile onto a boat, so that would be the unaccompanied site visit. You may need to look at the dock for weir. We don't know yet. We understand that a planning application is to come in late January for works on the dock for weir to accommodate the varying water levels in Loch Ness that would arise from the operation of the pump storage hydro. But until we see that application, I'll just have to leave it as saying that you might need to go and see the dock for weir on an unaccompanied basis.
If you are providing your responses to the matters raised by the applicant, etc., then in further written submissions, if you wish to kind of raise a request for that, then if you can do it through that process, that would be helpful for the relevance of why you would want me to visit that.
Sir, I had intended that would be set out for you. I just wanted to flag it up just now when you were discussing the topic of site visits, but certainly it will be set out in detail for you, sir.
Okay, that's helpful. Thank you. I think I've got myself distracted there. I think I've covered off the site inspection arrangements. We'll have this. Yes.
Sure.
Yes.
I just wanted to say on your observations for traffic and the duration of that, having been involved in observing traffic and traffic surveys, I know it's not a traffic survey per se you're conducting, but I don't think, given the length of this road and the number of settlements that this affects, that will be done in half a day. I think that's unrealistic. I think you need to timetable a day for that.
Okay, what I would ask you to do is you could input your position to the council, who would be coordinating the itinerary for that, and then we'll have that submitted prior to the hearing so that we can have a look at it and discuss it. But if you can kind of put that in and explain the reasoning for it, that would be helpful for me. But as I say, I can make the time available. I just need to make sure that it's relevant to what I need to look at and focus on. What I would say in terms of the site inspections, for those that haven't done it before, they're really there for you to point things out to me. I don't hear any arguments for the case during these sessions. They're basically to say, this is the junction we're talking about, these are the properties we're talking about, etc. So you can highlight things for me to look at, but it's not a further discussion. So all the discussion on the merits of the case should take place in the further submissions or the hearing statements. And what I'm going out on site of is to see the junction you might refer to in those matters, or the properties or the schools, etc., that you may refer to in any statement, so I can actually see them physically on the ground. So that was just going to set the scene of the purpose for me, is to see the things, not to have further discussion on site. I hope does that make sense in terms of the split between evidence and then actually seeing things on site?
100%. That said, you've got to get to at least 12 different locations for this.
Oh,
so
however long it, I have no issue.
To get between them alone, I think you will require a day.
I have no issue over the length of time taken. I will leave that for you to schedule with the council, and the council could coordinate that with the applicants in terms of the site visit around the site. Then I will go with what's advised to me. Whether I can get funding to go on the boat, I don't know whether I can put that through as an expense, but we will investigate that further, and I will come back to you on that, Mr. Kelly. Anything else on the site investigation? Inspection arrangements. The arrangements for document management. This is an important part if we go to the hearing process. The arrangements have been for the submission and management of documents have been revised, and there is a new guidance note, which I'm sure the applicant is probably well aware of now, and that sets out the process and procedures for managing documents. For those that are not used to the system, it means that any document referred to has to be listed within the foundation and supporting document list, which is put together by the applicant. But if you all can look at the guidance note 29 on the DPA website, I will put a link in the note of the meeting. That will explain the process. After reading it, if you've still not, or you've still got questions or queries, then please feel free to raise those directly with the case officer, Laura, who will be able to explain to you what you need to do for those matters. Okay. So item 11, that's the timetable for documents, written submission statements and recognition. Well, there won't be recognitions if we've not got an inquiry session. So looking at the key dates, I have provisionally set out my thoughts on this. So I will go through this slowly, and hopefully it will sort of be clear. So my intention is to get the note of the meeting out by the 3rd of December. So that will be the starting point for timescales. So that will be when the note of the meeting, that will also start the process for the further written submissions, so as listed in the agenda for this meeting. And also the foundation document list will be in progress with the applicant already. That will have been done separately. So what I would require from parties in terms of confirmation for participation, so by the 10th of December, I'd be looking for all parties to confirm their participation in the relevant sessions. So indicating what ones you will be taking part in. So the note of the meeting will explain it. So that would be by the 10th of December, so we know who's participating in what particular part of the process. Moving on to the 17th of December, that would be the deadline for parties to submit the requested further information that's set out in the further written submission. That's 14 days in order to do that. Given that we then, at the end of that week, go into the Christmas shutdown basically for 2 weeks, I would probably remove them from the timescale and would look for comments on the further written submissions to be submitted by the 14th of January 2026. If that works for people, that would be the deadlines for comments on the further written submissions. At that stage, a first set of draft conditions should be submitted, and also all of the returns for the foundation document list to the case officer should have taken place by that stage as well. I'll pause there because that kind of are there any questions on those timescales? If need be, we can tweak them, but I'd like to try and get this initial bit sort of fixed in place. Mr. Kelly.
Yeah, I need to give some thought to this because the matters that you have set out in your request for further written submissions from the board are not the totality of the board's case. So would there be a later stage of written submissions to follow on? That's one point. And the second point is that we're now looking at the hearings, if needed, being in mid-April. So I wondered if you had given any thought to tweaking the dates, given that we're now almost 3 weeks later in holding the hearings. So just 2 points, sir.
Okay. These were based on the 23rd of March dates. If it felt there was a requirement to get an extra week or two in terms of the submissions, we could tweak that if required. What I don't want to do is leave it running open-ended, but we could certainly push the dates on a week. So the submissions before Christmas could go on to the end of that week rather than the 17th of December, just the kind of last week before the Christmas break. It would take us well, it's only a couple of days, I guess, up to that point. If the 14th of January is too tight a timescale to respond back to, that could be pushed back either a week or 2 weeks. I don't know what parties feel, Mr. Finlay. I'll start with you.
Well, I'd be very keen that the initial submissions from particularly the Nest Board and the Council come in on the day you suggested. In terms of pushing back responses to those, I'm more ambivalent as to whether you give an extra week or an extra 2 weeks, but very keen to keep the responses, the initial matters that you seek to be in early or to be before Christmas.
Yeah, I think my own view would be that we need those initial ones. I need them in a sense before Christmas as well to start that vision, to be clear where we're sort of moving forward initially. So that date I would prefer to stay. The council, do you have any views on?
Well, I would agree it would make sense to have those before Christmas, but I think the 14th of January, in effect, is only sort of a week and a bit after the return from the Christmas holidays, so there'd be scope to push that out by a week or two, especially there's a number of people need to respond to that, and with the draft conditions, perhaps push that back a week to the 21st of January, or longer if others desire. But I agree, it makes sense to have a hard deadline before Christmas for the initial submissions.
Okay. I will look at pushing that date to give more time scale there. That would then potentially push on the other dates, which I will now have to work out in my head as we go along. But initially I was looking at statement of agreed matters and comments on the conditions by the 28th of January. That could be pushed to the 2nd of February if we're moving everything back a week. Sorry, forward a week, not back. Any problems with that as a timescale for those matters?
So just as a matter, just looking at my diary as a matter of personal preference, if you could extend the 1st January date by 2 weeks, that would certainly assist me, and then have the timetable thereafter.
Okay, so the 28th of January for the responses to the written submissions, round 1.
Yes, thank you.
Okay. You're testing my ability to count, but we'll get there. So looking at statements of agreement submitted, then that would be the 9th of February.
Yes.
For those. And obviously we're not going to require inquiry statements, so it's hearing statements to be submitted. Now, I'd originally had that as the 25th of February, so we could move those forward to either the 4th or the 11th of March. I think probably the 4th of March, because if we put rebuttals in, then we'd want a space for that. So 4th of March would be for the inquiry statements. The foundation document list and supporting documents should be pulled in by then. And then by that stage, a final draft set of conditions should be there. So I would think probably 2 weeks for rebuttal statements would take us to the 18th of March. Yeah. And then the hearing agendas would just go out the normal 10 days before the hearings, etc. And then the hearings taking place from the 14th of April. These dates can be tweaked by a day or two depending on how we go with that, but that just sends out our general thinking, and then any closing submissions would be after that. Any comments on that in addition to what's been said? Mr. Kelly? Your microphone is still muted, Mr. Kelly, so I can see your lips moving, but I can't quite hear you.
It seems to be taking a double click to unmute it. No idea why. In relation to the initial written submissions that you're looking for before Christmas, you still have them listed as 3 separate topics: water management, aquatic ecology, and fish. And I take it that the initial written submission is simply to specifically answer the questions that you have set out there, and that the board's full case would then follow in the hearing statement on the 4th of March.
That's what I would assume that you would be doing, is responding to the matters raised there, and then the hearing statement would be what you wish to consider at the hearing itself, clearly, and then the rebuttals will help to maybe narrow that process down.
I would hope so, sir. But that is, I'm very grateful for that, and thank you for that clarification.
Is that okay with other parties, Mr. Findlay?
Can I just? I mean, I don't need the board's full, or we don't need the board's full case, but we do need to know their direction of travel before Christmas, if possible, on those issues. So. It's an outline statement of case, not a full hearing statement, but it would be certainly useful to us, and I hope to you, to have the ambit of what the board's case is going to be on those topics, so that we're not taken by surprise and we can make and respond accordingly in due course.
Okay, I think there's obviously the response that the board are I'm requesting in terms of the position statement submission covers most of, I think, the concerns that were raised. So whether it's through that process that the board can narrow down and set out what it's taking forward, and that would allow the applicant to see the structure of the concerns that still remaining. Sir Kelly?
Yes, sir. We'll try our best to assist. I fully understand the process. But for example, under item 6 that you have in your further written submissions, water management, at the moment, the board can only set out limited comments on the operation of the Ness Weir until we see what SEPA are going to provide to you by way of further written submissions, and also until we see the planning application for works on the Weir. So in principle, we will try and comply with helping everyone, but there are matters where the board will also need to see further information before it can finalise its position. But Mr. Findlay has made a helpful comment. When I advise the board on what they submit in response at this first stage written submissions, I will bear in mind the concept of an outline statement of case, and I think that will that will definitely help if I have that in mind.
Okay, that would be helpful. Mr. Findlay, would that be of assistance to you?
Yes, it would. Thank you very much.
That's great. Thank you very much for that. Does anybody else have any comments on the timetable? Will be one of the appendices to the note of the meeting. So if you haven't got the dates all down, then that will be sent out so that you'll see the detail. Mr. Burnett.
Thank you, sir. One minor comment on the timetable in relation to rebuttals, maybe of assistance to Mr. Findlay as well. We are both involved in a case that week of the 18th of March. So if that could be pushed back a few days into the following week, either the 24th or 25th of March, that would still be 3 weeks before the hearing. That may be of some assistance rather than trying to finalise them while being involved in another case. And the other comment was in relation to the...
Mr. Burnett, can I just stop you? So just so I capture what you've just said there. So you're looking at the rebuttals.
You had 18th of March at the moment. We're suggesting postponing them a week or just under a week to the 24th or 25th of March.
Okay. That's fine. So I'm just counting back when I want to get an agenda out. So, yeah, if they're in by the 23rd, that's doable. That still gives me enough time to pick that up. Would that be satisfactory?
Or perhaps the 24th to have a day on the Monday to review them last
Okay.
weeks before.
I'm in a good mood, so we'll give you an extra day. How's that? 24th.
And the other matters are just in relation to the agreed statement of agreed matters. My intention would be to obviously consult with the applicant on that and involve Mr. Kelly, at least in the policy framework part, but provide our draft statement and allow for comments on it. But it'd be, I think, difficult to get agreement for all 12 parties to one particular document. So it may be that it's primarily an agreement between the council and the applicants, and then others can comment on that rather than having to be in full agreement with the wording of any document that's finalised.
Okay, sorry, Mr. Kelly, on you go.
Again, sir, we'll comply with what you set out in the minutes of the meeting. From the board's perspective, my preference would be to comment on what the council and the applicants agree, rather than trying to be involved in the detail of statement of agreed matters. So my preference would be to comment, but if you wish us to be involved, sir, then we will do that.
Okay, Mr. Finlay, do you have a strong view or opinion on the matter?
No, I think that it makes sense what Mr. Burnett has suggested. Thank you.
Okay, I think my position would be, my expectation would normally be for the applicant and the council to put together a statement of agreed matters so they've got clarity between those two parties. So I wouldn't be looking for the other parties, because trying to get, it'd be like herding cats, I think, if you tried to get 12 or 14 people to all, you might agree on one matter. What I think I just need to do is the difference between the applicant and the council, or where the disputes remain, and obviously the other parties can carry on raising their concerns as before. So I would expect the statement of agreement therefore to be between the council and the applicant if parties are content with that. Seeing you happy now with that, Mr. Kelly? Yes, thank you. Okay. Right, I will attempt to put that updated timetable, and that will go out in the note. I mean, if there's any comments on that, when you get the note of the meeting, if you can get them back to me as soon as possible, in case there's any other further adjustments. As I mentioned, closing submissions will take place in the normal manner at the end of the oral sessions, with the council and parties submitting theirs first, and then the applicant responding to that. And that would be the normal 14 and 28 days timetable, but that will be agreed at the end of any oral sessions. Moving on to 13, which is miscellaneous. Laura Walker is the DPA case officer, who I think most of you will have had some contact with by now. So if there's any issues or anything you need to liaise with, Laura is your contact, and there will be contact details in the note of the meeting as well. So this note of meeting will set out what was agreed today, and we'll come to a final conclusion on the procedures required, which I think we've got general agreement on those. It should be treated as a formal procedure notice and will be key reference to all parties. Before I move on from that, in terms of the further written submissions that are listed, nobody's raised any concerns apart from the applicant has highlighted their issue with the additional viewpoint which we covered. Of the further written submissions, are any matters in there that I need to be aware of, because these will form part of the procedure notice. Okay, Mr. Atkinson, you're still on mute. You'll need to unmute your microphone, sir.
That's it. Okay, thanks, sir. We've identified an issue with the carbon balance for the plant. We haven't raised that issue to date. Is it possible to still raise that as an issue at this stage in the process?
It's been, I think it has been raised in some of the correspondence that's come in, because I think I've noted that within that.
Yeah. What's happening here? Something.
Can you hear me now?
Yeah, I can hear you now. So thank you.
I think that matter has been raised in some of the comments that have come in, so it is something that I would take into consideration in sort of the report to Minister, so it would be covered off. I'm not saying that there's sufficient requirement for further information over and above what I've got with that at the moment, but is that something that you had wished to make further comment on?
Yes, I would like to put in a paper regarding the carbon balance, if that's possible.
It would have to be a request as a further written submission. What are other parties' views on that additional written submission, Mr. Finlay?
Well, it's very difficult to respond to that without knowing what it is. But if there is to be a further paper on that, it should be before you as soon as possible. So if necessary, we can look into it.
It would be if I was to request it, I would request it as a further written submission and obviously give you the opportunity to fully respond to that.
Yes, but it's just a question of timing, given it's a subject that we haven't been concentrating on so far. So if there is to be a submission on that, the pre-Christmas timetable will be the one that we would seek.
Yes, that's fine. Does anybody else have a strong view on that? Okay, I will include a request for that then, Mr. Atkinson, as part of that, but it would need to be in and submitted in terms of the timetable that we've set out today.
Yeah, understood that. Thank you, sir.
Okay, that's no problem. Okay, thank you for that. So item 14, any other relevant matters? Just to give people an idea who haven't been involved in the process before, we would normally start the oral sessions at 10 AM on the first day, if it's an in-person session, and then 9:30 sort of thereafter, finishing around about 4:30 PM and taking about an hour for lunch. And as I say, would be intended to webcast these as well. Are any part of... Oh, I think somebody needs to switch a microphone off. Thank you. Can I just say, if any party are considering making legal submissions that could affect the running of the hearing sessions, then they really need, or the inquiry as a whole, they really need to lodge them as soon as possible and not to wait until the start of the inquiry or hearing sessions. Delaying any legal submission really is contrary to the spirit of prior disclosure, so that results in being wasteful of expensive inquiry time and, most importantly, unfair on other parties. So if there are any potential for legal submissions, then they really should be raised as soon as possible and not left to the last moment. So on that basis, I will now proceed to finalise the note of this meeting and plan to issue that, as I said, by next Wednesday, with all the dates and flowing from that date as a start of the formal process for further procedure. As I said, parties will be asked to confirm once they've received that what hearing sessions that they intend to take part in. Before I close the meeting, is there anything else that anybody wishes to raise with me today? I'm seeing all shakes of head. Well, all it is to say is for me to thank each and every one of you for your very constructive participation today. I hope I've explained the process to you and there's some sort of clarity in where we're going, taking things forward. And as I say, the note of the meeting will be issued next week And if there's any questions on that, clearly you can come back and raise those directly with through the case officer. Okay, well, thank you all very much for your participation today. The meeting is now formally closed. Thank you.
Thank you.